We'll go ahead and start. There is food, though, for everyone. If you'd like to get it now or after the initial talks. So welcome to the final session in our series on European and North American approaches to international law, human rights. I want to just say a bit about that because some of you have been here for every session. Obviously, the students have, but others as well. So we've covered 5 topics so far: counterterrorism, immigration, racism, and xenophobia, freedom of religion. That was actually one topic: immigration, racism, and xenophobia. Freedom of religion, employment discrimination, universal jurisdiction 2 weeks ago, and today, labor rights. And I do want to take an opportunity to say thank you to European Studies for all of their support in helping us put together this collaborative speaker series. And I want to thank Billy Chandler for helping out. Everybody knows what he does. See, now the emails go out and say Rapoport Center, but you all still know that's Billy Chandler writing. So Billy's made sure that everyone has gotten here during the semester, and he wrote their talks for them and stuff. No, but we've had a semester full of a lot of cancellations across campus, and not one here. So he even managed the weather for us. And then I also want to thank the seminar students who are sitting mostly over on this. You all found your seats and have kept with them the whole semester, for your eagerness to learn about new topics and ways of thinking about them, and all the hard work that you put into learning about a bunch of different areas of law from different places. And to the pretty regular audience we've had of students and faculty from the law school as well as across campus, and a number of people from the community. So it's been a terrific series. And we've had a great array of speakers, but the best ones you're going to hear today. So we saved the best for last. It's on tape. And I will say I know both of today's speakers quite well and have known them each for a long time, but they don't know each other so well. So it's been a pleasure to get them talking to each other more directly about labor law, and I'm glad to share that conversation with you today. So I will introduce Mitchel Lasser first, and then Kerry Rittich, to give you a sense of how we're going to do it today. Mitchel will speak for about 20 minutes, and then Kerry will speak for about 25 minutes, partly responding to Mitchel, and then giving her own presentation, and then Mitchel will respond to that. So Mitchel Lasser is the Jack G. Clarke Professor of Law and Director of Graduate Studies at Cornell Law School. And he also co-directs the Cornell Summer Institute of International and Comparative Law in Paris. In addition to being a legal scholar, he has a PhD in comparative literature, and he even did that after becoming a lawyer. So if you see any influence, it's partly from that. He teaches in rights in the areas of comparative law, law of the European Union, comparative constitutional law, and judicial process. He's the author of many law review articles, as well as 2 books: Judicial Transformation, The Rights Revolution in the Courts of Europe in 2009, and Judicial Deliberations, a comparative analysis of judicial transparency and legitimacy. And he'll be applying a lot of the work that he's done on comparative law and then on the European Union to labor law issues today. Mitchel has also visited at a number of universities in Europe as well as in the United States. And maybe the most important is that before he moved to Cornell, he was the Samuel D. Thurman Professor of Law at the University of Utah, where we were colleagues for, 8 years or something. Last year. Now we've grown up a bit since then. So Mitchel's talk is entitled Fundamentally Flawed: The CJEU's Jurisprudence on Fundamental Rights and Fundamental Freedoms. Kerry Rittich is professor of law and also of women's and gender studies at the University of Toronto. She's been here before and has, so a number of people have gotten a chance to learn about labor law and other topics from her, and it's great to have her back. I will say, in addition to being a legal scholar, Kerry is also, or was, a professional musician, so you might listen for some melody in her talk today. She teaches, or harmony, maybe, or disharmony. Anyway, she teaches and writes primarily in the areas of labor law, human rights, and their intersection, and law and development. She also has many publications, including 2 books, Labor Law, Work and Family, Critical and Comparative Perspectives, and Recharacterizing, Restructuring, Law Distribution, and Gender in Market Reform. And Kerry also has visited at other schools. She was the Mackenzie King Visiting Professor of Canadian Studies at Harvard. And her talk today is entitled Fragmented Work and Multi-Level Labor Market Governance, Labor Law in Crisis. And I will say that both Mitchel and Kerry gave to the class very recent articles they'd written, book chapters, but they're both planning to continue to work in the area. So this is sort of a mix of work they've already done plus some work in progress. And please join me in welcoming Mitchel and Kerry.
So I guess I will just start. You actually want me to come up here?
Yeah.
Well, if I come up here, I would have to move this. Should I actually move this?
Sure.
Okay. How formal of you.
But that's all.
It's terrible. That's okay. I think I have enough power here to go, but I guess I might as well.
It's for the camera.
Holy smokes. I have to move the soda. So this is a great pleasure, I have to say. Thanks a ton, Karen, for inviting me. As Karen said, we were colleagues for a bunch of years at our first jobs at the University of Utah, and I've tried ever since to make excuses for Texas having stolen her, and I still can't quite get over it. So I'm really still annoyed at Texas for having taken Karen away, even though I've moved on from Utah, and I'll try and forgive you all. Thanks also to Billy for helping to make this practically possible, and to the students who wrote a bunch of really insightful comments on both of our papers I've read. So thanks to all of you. So what I'd like to do is to first give you a little sense of the structure of what I'm going to do for the next 20 minutes or so before I hand things off to Kerry. First, what I'd like to do is to give you sort of a big picture context for the article that I sent and that some of you have seen, which is a shorter version of a longer thing that I was supposed to have gotten done by now but have not. So all comments will be useful. So the main questions would be, where does the project come from and where is it looking to go? Then I'd like to ground the discussion a bit by giving a very brief discussion of the ECJ's relatively recent judgment in the Viking case. By the way, I'm saying the ECJ and not the CJEU. It's the same thing, okay, but it's the ECJ, all right? And then finally, what I'd like to do is to explain a bit how I'd like to use the Viking case, both to generate a different descriptive reordering of the traditional American comparative law understanding of European civilian systems, and to critique the reordering that the European legal system is actually producing. All right, so that's the agenda, more than enough for 20 minutes. All right, so first, context. When I first came into the law teaching business, now almost 20 years ago, I spent a bunch of years trying to challenge the core American comparative understanding and critique of civilian legal systems in general and of the French legal system in particular, the French model being usually taken as the flagship or the lowlight of civilian systems, depending on your perspective. Now, according to this traditional American comparative understanding, the French legal system, and by extension civilian systems generally, were crippled by a Revolutionary era French fear of judges. And as a result, civilians continued to insist through the centuries that their legal orders be almost judge-proof, right? Leading the French judiciary, even now, to hand down judgments, especially at the high appellate levels, that are no more than a single sentence long. They're abstract judicial syllogisms that mechanically and seemingly formalistically apply the codified commands of the legislature. So I spent some, 10 years chipping away at this self-serving, seemed to me, American comparative myth, trying to demonstrate that the French actually deployed an intriguing set of institutional, professional, and conceptual arrangements that produced a thoroughly defensible, I'm not saying sublime, but thoroughly defensible institutional and Republican judicial alternative to the more argumentative and populist American model. All right. Having finalized that analysis in my first book, I became increasingly fascinated by a stunning set of transformations that were rocking the European legal universe so thoroughly that even the notoriously impervious French judicial system was changing at breakneck speed. Right? And that transformation has been an honest-to-goodness fundamental rights revolution. Now, the first order of business for me was to try to figure out not only how and why that fundamental rights revolution was occurring, but how it could have transformed the French and European judiciaries so thoroughly and so fast. My conclusion, which I spelled out in my last book, was that the concurrent French and European fundamental rights revolution is not only an intellectual development, it's also the product of a competitive structural dynamic between the numerous high, let's call them supreme courts in play at both the national and the supranational levels. All right? So you see, first, the European judicial arena possesses two layers of powerfully operational courts, the domestic and the European supranational judiciaries. And second, almost all national judiciaries in Europe belong to the civil law tradition. And as a result, they typically possess multiple and often quite distinct judicial hierarchies, each headed by its own Supreme Court. The French situation is typical. There's the Court of Cassation, which is the tribunal of last resort for civil, commercial, and criminal matters. There's the Council of State, which is the high court that resolves public, executive branch, administrative law questions. And then there's the Constitutional Council, which handles constitutional questions. And to have three separate high courts like that is totally standard fare. In fact, even the European supranational judiciary is led by two different courts. The European Court of Justice, what I'm calling here the ECJ, which is the European Union's top court, and the European Court of Human Rights, the ECHR, which applies the European Convention on Human Rights. So the European domestic and supranational judicial orders therefore possess a plethora of high courts that operate in an overlapping and richly interactive judicial environment. And this multiplicity of high courts has led to interinstitutional dynamics that first and foremost are prompting a group convergence of all of these courts on the fundamental rights idiom. Almost every European judicial player now faces powerful pressures to jump on the fundamental rights bandwagon or be left intellectually and institutionally behind. Second, this required convergence has forced these respective courts to translate their prior procedural, doctrinal, and conceptual schemes into fundamental rights terms. Third, the struggle to master and direct these legal developments has further reinforced the rising fundamental rights regime, because the most empowering strategy for any given court is not to attempt to avoid or opt out of the often very disruptive fundamental rights regime. Not only does such a refusal appear retrograde, it leaves the institution at the interpretive, doctrinal, and institutional mercy of those courts that have taken the opposite tack. By far the more effective strategy is to embrace and even seek to lead the emerging regime by aggressively developing expansive fundamental rights positions. This maximalist approach, so to speak, is the most effective means to disable and trump troublesome interpretations by legal competitors, to maintain control over one's own institution, and to exercise institutional and intellectual leadership of the emerging judicial order. All right, so this has led to a kind of frenzied and inflationary race to the top of the fundamental rights interpretive ladder, in which most courts such as the ECJ in the Viking case, find it in their institutional interest to define more and more legal issues between more and more parties as fundamental rights conflicts. All right, so it's through this prism, and not really as a labor lawyer, that I come to the Viking case, which, along with its sister cases before the ECJ, has made quite a splash over the last couple of years. Okay, so the Viking case. Let me take a minute to summarize the litigation so that at least you have some idea of how I want to use it to advance my descriptive and normative claims. The case comes out of a totally routine collective bargaining situation between labor and management at Viking Lines, which is a company that runs ferries in and around Finland. One of Viking's ferries ran the 2-hour route between Helsinki, Finland, and nearby Tallinn in Estonia, which is a new EU member state. Viking wanted to lower its costs by reflagging the vessel in Estonia, whose labor costs are a small fraction, and I mean like a quarter of those in Finland. At the end of the collective bargaining agreement, the union bargained hard for Viking to agree not to reflag the vessel in Estonia. And they backed up their bargaining position by threatening to strike if Viking didn't agree to this concession. Right? This was, by all accounts, perfectly legal to do under Finnish labor law. Okay, to make a long story short, under the traditional Finnish collective bargaining regime, Viking management is no match for labor, so it eventually accedes to the union's demands. But then it gets a brilliant idea, to sue the union on the grounds that by acting as it did, the union had violated the firm's fundamental freedom under European law to move freely within the European Union to establish its business where it wished. That's the EU's so-called four freedoms are the freedom of movement of goods, persons, services, and capital. And by the way, it manages to bring that suit not in the potentially hostile Finnish labor institutions, but in the infinitely more congenial British commercial courts. Okay? Now, in response to this sweeping claim about the firm's fundamental freedom of movement, the unions had one of their own, namely that they had a fundamental right under European law, not just under Finnish constitutional law, to engage in collective action, including both the right to strike and the right to engage in secondary action, including boycotts. So the case presents itself at the European level as a conflict between the fundamental European legal interests of two private actors, a conflict between the firm's fundamental freedom of movement and the union's fundamental right to collective action. So what does the ECJ do? In short, one, it recognizes both claims under EU law. That is, it recognizes the firm's fundamental freedom of establishment and the union's fundamental right to strike. Two, it then balances the fundamental freedom against the fundamental right to determine whether the unions were justified in exercising their fundamental right to collective action to encroach, as they did, upon the firm's fundamental freedom of movement. And finally, it concludes largely in favor of the firm and against the union. A stunning and highly publicized defeat of the unions that only gets further entrenched in a couple of sister cases out of Sweden and Germany. Okay, so why my interest in Viking, given that I'm a comparatist and not really a labor law professor? On one level, I want to use it as a case study of what European legality increasingly looks like today at both the domestic and the supranational levels. Because it's in fact a telling example that suggests a series of broad comparative conclusions that subvert pretty thoroughly our traditional American comparative understanding of European civilian systems as a combination of codified law and self-effacing judiciaries mechanically applying that codified law. First, it demonstrates the full extent to which it's becoming impossible to study leading European civilian legal systems, which after all is the heart of the comparative law discipline as traditionally constructed, without putting European law and European supranational courts at the heart of the analysis. Europe has become a conglomerate legal order with the domestic and the supranational dimensions increasingly in play at all times. Right? This dovetails with Kerry's writing quite a bit. Second, it demonstrates the tremendous judicialization of those legal orders. are increasingly governed by a group of unabashedly powerful courts who hesitate less and less to handle the most routine cases, including private law cases, as path-breaking fundamental rights cases governed above all by fundamental rights jurisprudence. Third, it therefore illustrates rather well the transformation of European civilian legality into what I call, half-jokingly, a fundamentalist system increasingly dominated by judicially managed fundamental rights and fundamental freedoms. In short, Viking shows the fundamental rights and fundamental freedoms dynamic in operation. It shows how the ECJ effectively trumps an entire branch of domestic law by absorbing more and more into its fundamentalist framework. A routine domestic collective bargaining dispute under Finnish labor law is transformed into a clash between a European fundamental freedom of movement and a European fundamental right to collective action. In fact, the transformation is so successful that it's the parties themselves, who know perfectly well that fundamental rights and freedoms are now the strongest coin in the realm, who are each, on their own respective sides, prompting the ECJ to resolve the case in fundamental law rather than labor law terms. Okay, so on the first level, I want to use Viking to help produce a descriptive reordering of the traditional American comparative law frame. But on a second level, I want to use Viking for the purposes of explicit critique. I'm actually quite uncomfortable with what I'm calling European fundamental rights fundamentalism. That is, the incredible absorption of ever greater swaths of the European domestic and supranational legal domains into a unitary and undifferentiated legal order regulated by an increasingly unitary system of fundamental rights and freedoms. Now, this critique operates on a bunch of levels. First, European fundamentalism is swallowing up more and more of the European domain, and its supranational legal universe is being constructed on that basis. For this to occur, fundamental rights and freedoms have to become more and more applicable to more and more defendants in more and more subject matter areas, and this is exactly what's actually occurred. There's been a doctrinal progression that makes more and more defendants liable to be sued for violations of fundamental European legal norms. First, state actor status was expanded, then state-like regulatory actors like international sports federations were covered, and so on and so forth, until we reach Viking, where a private union is held liable for violating fundamental norms simply for exerting routine collective action pressures in a routine collective bargaining situation. This makes it increasingly difficult to regulate legal relations in some manner other than by judicially controlled fundamental rights and freedoms. Labor law is no longer a truly distinctive regulatory space anymore. In fact, even routine and purely domestic private law disputes, like torts and contracts cases, are being resolved through the same basic fundamentalist framework. Imagine a routine French malpractice claim turning on the physician's fundamental right to exercise a trade versus the patient's fundamental right to dignity and bodily integrity. That was actually a major French decision from about 5 years ago. Now, all of this convergence on fundamental norms raises technical doctrinal problems. Think about it. Increasingly, every dispute becomes a right dispute, with each side claiming its position as fundamental right. That's the world of Viking. So the judicial decision maker, and now there always has to be one, has to put forward a unitary and overarching decisional structure that's capable of resolving these massive and endless and yet suddenly utterly routine fundamental rights disputes. And this decisional structure can't help but be terribly simplistic. After all, how on earth is a judge to measure in every routine controversy whether, for example, the structure of a country's entire system of labor relations jives with the free movement of goods, persons, services, and capital? Answer, the judge won't and probably can't. There are just too many cases, they're too systematically and politically complex, and they're too highly charged. So what's the judicial response? To break down all of these massive systemic questions into individual rights violations, and then to run them through a unitary decisional matrix, namely the judicially created multi-part test known as proportionality analysis. And that's how you end up with a judgment like the one in Viking, in which the ECJ holds that a private union's exercise of its fundamental right to collective action doesn't justify its encroachment on the firm's fundamental freedom to move part of its business elsewhere in the European Union, unless the union strike threat, 1, has a legitimate aim compatible with the treaty, 2, is justified by overriding reasons of public interest, 3, is suitable for securing attainment of its objective, 4, doesn't go beyond what's necessary to attain that objective, that is, there exists no less restrictive means to attain it, and 5, has only been taken after the exhaustion of all other alternatives. And as you can imagine, this is just a disaster for any system of collective bargaining, never mind for the union. A union must now subject every one of its own acts to a judicially enforced and created proportionality analysis in order to determine whether it violates management's fundamental market freedoms. And this kind of case-by-case normative assessment, subject, needless to say, to what unions the world over have fought hardest to avoid, namely judicial review by non-specialized courts, trumps just about any domestic or supranational attempt to regulate particular legal fields, such as labor law, by distinctive institutional rather than generally applicable normative means. After all, it used to be the case that labor disputes in Finland were resolved by a specialized labor institution that, though technically called a court, was really anything but. It was composed of knowledgeable representatives of labor management in the state, who mostly let labor and management hash things out on their own, relatively unconstrained by traditional tort, contract, antitrust, or even criminal law, and an institution that, if really pressed, resolved any residual conflicts in a legally unreviewable manner that was geared first and foremost towards getting everyone back to work and maintaining industrial peace, not in a manner that valued the judicial imposition of superior and generally applicable legal norms. But as Viking demonstrates so well, such traditional institutional arrangements are now under imminent threat as the rise of fundamental legal norms at both the domestic and the European levels increasingly drives everything into an undifferentiated normative universe governed by dominant and judicially applicable legal rules. All right, so I think that's plenty for now. So why don't I just hand things over to Kerry, who's the real labor law specialist.
Thanks, everyone, for joining us today. Thank you so much, Karen, Professor Engel, for the invitation. It's really wonderful to come back. And thank you especially to those of you in the workshop who took the enormous pains that you took to comment on our papers. And I think both congratulations and apologies are in order. Congratulations because of the sophistication which you clearly demonstrated in your comments. But also, the papers that we circulated, for those of you who are in the room and didn't read them, are really quite disparate papers. And putting the two together is a bit of a challenge. But I will say that in some senses, they're quite representative of the universe, the very broad universe of claims in respect of workers' rights and labor rights that can and are being made right now within the framework of fundamental rights and human rights. So what I thought I would do is the following. I want to just pick up exactly where Mitch left off and just emphasize a little bit about why a decision like Viking might give such unease to labor lawyers and people who are generally interested in the position of workers right now, and suggest that it's not only because the decision was one in which the unions and the workers came out on the latter side, but the bigger question, the more interesting question, is what's at stake for workers in this turn towards fundamental rights, towards human rights. It's something that we see not only in Europe, we see it to some extent in the industrialized world, but in particular in respect of transnational labor disputes and workers' rights in the global economy. Human rights is the framework, the dominant framework for thinking about all of these questions. So one of the questions that labor lawyers, particularly international labor lawyers, are trying to think about is, all right, what do workers gain, what do they lose, when we start to reframe all of these questions in terms of basic rights. Second thing I'd like to do is spend a little bit of time talking about the encounter between workers' rights and fundamental rights on this side of the ocean by looking at what the Supreme Court of Canada has done in respect of workers' rights claims under the Charter of Rights and Freedoms, which is the Canadian Bill of Rights constitutional document. And finally, I'll speak to the general issue that is in the paper that I circulated, namely, what might a labor law adequate for our times look like? A labor law that captures the dynamics of a transnational post-industrial economy in which there's an enormous gap between the jurisdictional reach of the nation state, which is the traditional site of labor law, and the ways in which work and production are now organized. And in particular, I'll talk a little bit about the claim that we need a broader approach to the law of work. We need to think about labor law, beyond the discipline of labor law, by looking at what happened both to labor law and to general policies of interest to workers in the context of the financial crisis. So thinking about macroeconomic policy as potentially something that's part of the law of work, at least in some places and sometimes. Okay, so just a brief word on why there's such enormous emphasis on the values of self-regulation and autonomy from courts. This is not something that's particular to labor lawyers in Finland. It's a very long-standing preoccupation of workers and unions in the Anglo-American world in particular. It's partly because not only were courts not especially sympathetic to the interests of workers, as late as the 19th century, the traditional activities of unions gathering together to try and organize and act collectively in aid of better terms and conditions of work was simply criminal activity. It was criminal under laws of conspiracy. There has been an extremely interesting dynamic between courts and legislatures in this area. When legislatures stepped in to try and do things about wages and working conditions, which of course they did almost as soon as the Industrial Revolution got going, and systematically substandard terms and conditions of work were everywhere to be found, courts would routinely use their powers in quite an aggressive manner to either declare that such legislative interventions were illegal or unconstitutional, and this is of course the history of the realist revolution in the United States. An enormous amount of the jurisprudence and the analysis of the relationship between courts and legislatures concerned precisely the issues of workers and labor standards. So there was a whole question of the role of the courts in policing legislative action to try and improve working conditions. But courts were also quite active in simply inventing new forms of liability in tort law, for example, or using injunctive relief against workers. And even the Supreme Court of Canada says just quite bluntly, quite frankly, that the labor injunction was used all over the Anglo-American law transparently, quite transparently, as an instrument at the behest of employers and against the interests of workers. So this is the history behind the rise of courts, specialized labor courts, administrative structures, and the enormous efforts that you can see in many places of the world to simply keep courts out of this area. And there was a sense that not only were courts likely to be somewhat hostile to the interests of workers, but there were really good reasons to suppose that general expertise in interpreting rights and reading contracts wasn't actually adequate to quell labor disputes. That you actually need to know something about how industries work, about standard practice among employers and workers, and that knowing something about that makes a significant difference to how you're likely to resolve a dispute. So that's, I think, worth bearing in mind, or at least that will give you a sense of what labor laws are thinking about when they're confronting a specter of the displacement of labor law by human rights, and as in Europe, a situation in which human rights rather than labor law is the organizing framework here. Okay, I thought I would say that the specific problem that arises in Viking is there are many reasons why Viking is a fantastic case to think about. It is a very, very famous labor case, but there are many reasons why it's an excellent case to think about and to think with. And one of them is that the fundamental clash that Mitchel described, the clash between the rights of the employer, the freedom of establishment that the employers enjoy in the European Union, and the rights of workers, is simply the latest iteration of a conflict that's been playing out for well over a century, which is a conflict between, let's call them settled commercial expectations, expressed in private law rights of property and contract, and often buttressed through things like the business judgment rule in corporations law. You've got those rights on the other side, and the rights of workers to bargain collectively, to organize, and so forth on the other. And the interesting thing is that even when there is no explicit constitutional protection to employers' property and contracts rights, as there is not in Canada, courts are often, for good reasons, but very inclined to read the scope of workers' rights in ways that preserve, to the extent possible, those traditional entitlements rather than upend them. Now, why does this matter? Well, it matters because the whole purpose of labor law is to interrupt those rights and to reallocate the bargaining power and the entitlements as between workers and employers. That is, in some senses, the raison d'etre of labor law and labor standards. In any event, this is the standard conflict. It's been playing out for over a century in the domestic courts of all of the industrialized countries, and versions of it are clearly visible in international law, and even in the new non-state private modes of setting labor standards, for example, corporate codes of conduct. Okay, I want to say one thing about the question of institutionalization, because one of the key issues is the distinction between the declaration of rights in the abstract and the presence of legal entitlements that actually ensure that those rights can be acted upon and realized in particular ways. One of the things that we know in labor law is that abstract declarations of rights may not be especially helpful, especially if there are no remedies, if there's no administrative machinery to enforce these rights, and so forth. So that's one thing to pay attention to. Maybe we can talk about it more collectively. And the second related point would be simply to notice that the absence of institutionalized protection for workers' rights creates an asymmetry in the entitlements of workers and employers. Because employers, of course, do have legally enshrined rights that they can and routinely do rely on property and contract rights and so forth. So that is a persistent issue. Okay, let's say just a little bit now about what has happened in the Supreme Court of Canada in the encounter between workers' rights and trade union rights and fundamental rights. And just by way of background for those of you in the room, Canada has a US-style labor relations regime. Our labor relations acts are modeled on the 1935 National Labor Relations Act. We share an enormous amount with you in the way we organize our labor relations. We've got some key differences, but basically, if you know how US labor law works, you'll know a lot about how Canadian labor law works. All right, so we have in Canada a relatively recent Bill of Rights. The Charter only came into force in 1985, and so in some senses, we can put Canada in the rights revolution as well, in the sense that we've had a relatively short generation of enormous transformation in the form of judicial oversight and judicial review of legislative and executive action. That was just largely absent prior to 1985. And since the introduction of the Charter, unions, workers' rights groups have attempted to use constitutional rights, freedom of association in particular, to advance and protect the interests of labor in a number of ways. One of the things that they've tried to do is challenge legislative prohibitions on traditional union activities. For example, prohibitions on the right to strike, which are found in public sector collective bargaining laws. The very first case that came before the Supreme Court of Canada was a challenge by the nurses of Alberta who were prohibited from striking under the terms of the labor relations legislation that they were offering. The Charter has also been used to challenge the exclusion of particular groups of workers from the general labor relations regimes, in particular the exclusion of agricultural workers. This has been a very big issue. And finally, it's been used to challenge legislative action which has the impact of retrospectively impairing rights that were bargained, collectively bargained. Okay, but that's only half the story. The other half of the story is equally important, and that is the use of the Charter proactively to attack labor rights and labor relations schemes. For example, challenges to the obligation to pay union dues on the basis that they interfere with workers' freedom of association, or arguments that the obligation, a very particular obligation, in fact, to select a particular union if you're a worker in the construction industry to represent you at the bargaining table similarly violates freedom of association. These cases are very interesting because it turns out that the vast majority of them have actually been instigated by employers who are simply finding and funding disaffected workers to use labor rights to advance their own interests. Now, I think for the purposes of our general discussion, it's probably worth saying a few things about how the Supreme Court of Canada has traditionally, or how they analyze these cases. And the most important thing when they heard the very first case on the scope of freedom of association was that the touchstone or starting point for their analysis was simply individual rights. And they came to the conclusion that freedom of association under the Canadian Charter basically protected your right to form and to join a union and to do collectively anything that it was lawful or constitutional for you to do as an individual, but it didn't go beyond that. It didn't give any protection to activities that really only had meaning in a collective sense, and it gave no protection to either the objects or purposes for which people join unions. Namely, no constitutional protection to striking, bargaining collectively, and so forth. And this decision, very early on in the life of the charter, essentially froze the landscape for a long period of time. It greatly restricted any effort to actually use the charter to advance the interests of labor. Now, in the intervening time, there were a few interesting developments. So in a case called Dunmore, which concerned the right of agricultural workers to bargain collectively in 2001, the court did get around to recognizing that there might be something distinctive distinctively collective even, in workers' freedom of association that couldn't be adequately captured by individual rights. Nonetheless, despite this recognition, we saw in that case what we have seen basically ever since, which are declarations and recognition of these interests, but decisions that in effect generate almost no practical utility for workers. Now, why is that the case? Why is it that even when workers have seen improvements in the recognition of rights in the abstract, what is it that, or what are the devices by which the transformative reach of these rights has been contained? Because I think in some senses that is what lawyers who are thinking about this are interested in. Here are some of the things the court has said. And one of them is that it's not prepared to constitutionalize any particular set of legal or institutional arrangements that protect workers' rights. So for example, it won't give constitutional status to a Wagner Act labor law regime. You can have workers' rights in the abstract, but that doesn't mean you get access to the Wagner Act. It doesn't mean you get the full panoply of labor rights that workers who can shelter under that act actually get. They say that over and over again. Why? Because relations between workers and employers, between labor and capital, are political issues. They involve the balance of social powers, and they say, you know, this isn't our department. This is the province of the legislature, of parliament, of Congress, of whatever. So they're very chary about stepping in and saying anything about these arrangements. They don't want to freeze them in particular time. So bottom line, workers have some rights in the abstract, but they have not provided an especially great way to strengthen workers' rights. Now, how am I doing on time, Karen? I just want to. Okay. So I can say more about this, but I think that I want to draw a link with something that Mitch said about baking. And that is that the European Court of Justice did recognize workers' fundamental rights in that case. And everyone thinks this is fabulous, and that this is a victory for unions. And so I would merely raise a note of caution here, because I think it's completely apparent if you look at the evolution of these cases. Oh, and one other thing I should say too is that the Supreme Court of Canada adopts in its constitutional adjudication and jurisprudence a proportionality framework and test that's very, very similar to the one that Mitch described in respect of balancing incursions into fundamental freedom. So there's a family resemblance in the tests, if you will. But here's the note of caution, and that is, suppose, like the Supreme Court of Canada, they do recognize a right to strike, a right to bargain collectively, or any other particular right. It might well, in fact, give minimal protection for workers' interests and action. And actions. In the two most recent cases on labor rights, the Supreme Court of Canada did recognize a right to bargain collectively, but it turns out that, once again, there's no access to specialized tribunals, to the administrative machinery. You can't deploy the elaborate jurisprudence that labor boards have developed on both sides of the border in the US as well as Canada in the service of understanding what, for example, a right to bargain collectively and the duty to bargain mean, right? That stuff is just completely closed off. So the idea would be a right in the abstract can, of course, be interpreted in many ways. It can be read broadly, it can be read narrowly, and I think there are reasons to just be cautious a little bit about what to expect from those sorts of moves. Okay, now, so I mentioned at the beginning that the move to fundamental rights and away from labor law proper is not something that's specific to any region. It's in fact, if the view from 30,000 feet, you can see it as a general trend. You can see it in many, many places, which is of course the reason that labor lawyers are thinking so much about human rights and the move to fundamental rights. What's going on here? Why is this going on? Well, just briefly, in part it's, especially beyond Europe, but it's visible there as well, a result of the declining presence of unions, and also the growing irrelevance of unions and collective bargaining structures in their traditional forms to growing numbers of workers. This is the problem that we refer to in labor law as the decline of the standard employment relationship and the rise of various forms of atypical, often precarious forms of work. So this is a problem on two levels. The most immediate problem is that the decline of the standard employment relationship is associated in general in the industrialized countries with simply lower wages, less economic security, less voice and control at work, just worse work, if you want to put it that way. But it's a problem at another level too. It's a problem because the standard employment relationship is the normative basis of labor and employment law itself. And as the standard employment relationship has declined, what's happened is that more and more workers find themselves beyond the reach of labor and employment law, literally outside of its protective net entirely, and basically just subject to normal market pressures that commercial actors are under. This is a big part of the story. Something else, I mean, there is, I think it's fair to say, just declining sense that of the importance of collective rights or solidarity rights per se. And I can say I have experienced this even as a teacher in the not such a long time that I've been teaching. I've been teaching for about 15 years. I would walk into the classroom and I would start my introductory lecture on labor law and talk about why we have unions and why we have collective bargaining law, and there'd be nods of agreement, and you can tell as a professor if your class is with you and when they're not. And then at some moment in time, I realized that the people in front of me had no idea what I was talking about. They didn't actually have any particular experience of unions in their families or as individuals, and they didn't have any understanding about why an individual right might not be an adequate substitute for a collective right. This is, I think, not just something that happened to me. I think it reflects a broader shift in the climate that's part of what is going on. And labor law in particular is suffering because of the broader anti-regulatory climate, which has also been part of the legal and normative landscape for the last generation, particularly in the international sphere, but I think anyone in the United States would recognize this as well. And the basic problem here is that workers' rights and labor market institutions have become associated both fairly and unfairly, with impediments to the efficient operation of markets and the effective allocation of labor resources. And so there's an assumption that they're second best solutions at best. You might want them for particular purposes, but you're going to pay a price either in terms of economic growth or higher levels of unemployment. Okay. The paper that I circulated, Fragmented Work and Multi-Level Labor Market Governance, is really just an intervention in what is a very general conversation among labor scholars, which is namely how to rethink what labor law and the law of work should look like in this changed normative and economic landscape, but in particular, if we're interested in the status of workers, not only in the industrialized world, but in the developing world and the emerging markets, when vast numbers of workers work either in informal markets or are really very difficult to distinguish just from small petty traders and entrepreneurs, right? It's a big challenge to think about what labor law would look like. And I want to sit down shortly, so let me just say the basic idea here. The argument that I'm running in this paper is really twofold. The first one would be we need to pay attention to a whole raft of other legal regimes beyond labor law and employment standards on the theory that many, many other forms of law are actually partly at work in determining the bargaining power that workers have and can exercise vis-a-vis their employers. They're critical to the presence or absence of work, and that we should start thinking of them as part of the broader law of work, right? And second, that we also need to step back a little bit and think about how we are producing, through law and policies, a very wide range, the forms of problem that we then want labor employment law to solve, right? So rather than simply ask, what should labor look like in the future? How could we better protect workers? Because we are so systematically now producing bad, substandard, not very good work, I think we need to step back and ask, okay, what's the nature and the family of legal rules, decisions, and institutions that seems to be systematically doing this? The idea this should be part of a labor law agenda too. And I illustrated this in the paper simply, as those of you who read it know, and I'm delighted to take some questions on this further, by looking at the impact of fiscal and monetary policy on workers, particularly but not exclusively in Europe during the financial crisis, but also looking at the response to the financial crisis and its impact on labor law, because it was bailout conditionality, particularly for the countries that were in deficit position, severe reductions in in labor standards and workers' rights, and sometimes employment itself, were the price of getting access to funds to stabilize economies. And so labor law is in somewhat chastened and weakened state on both sides. Okay. So do you want to go first?
I mean, I guess I don't have anything in particular to say. I mean, I guess, oh, should I go ahead?
Oh, I'll move it down.
Okay. Other than to say this all makes sense to me, I think that we're really talking very much the same set of issues. I guess the only thing I would do is to stress the full extent to which labor and its legal supporters are in a bind, right? As I see it, at least on the legal side of the equation, they're really in a bind. And that is, on the one hand, they can't just stand on the sidelines as the entrenchment of fundamental rights and freedoms are advanced by firms and by management, and do nothing about it, right? I mean, that's just a losing position. And on the other hand, to the extent that they're responsive to those fundamental rights and freedoms as a field for legal wrangling and legal definition of rights, the more they engage in that conversation, doing the logical thing of trying to develop and to acquire for themselves parallel rights, the more they're engaging in a kind of legal regulation that is precisely the kind of legal regulation that they sought forever to try and get away from, right? And that's really a wicked bind, right? It's turning to the courts and turning for a kind of regulation at the hands of particular kinds of state actors that they really traditionally want to get as far away from as they can. And on the other hand, how can they just relinquish the field? They can't just relinquish the field, right? So Viking, to some extent, is symbolic of this situation where, in theory, they've gained something, right? They've gained a right that, in theory, absolutely could be interpreted in a manner that would be empowering to some extent. Now that said, can one really be confident that that's the way it's going to be interpreted? I think that to some extent the proof is in the pudding. And when push comes to shove and the two kinds of rights, which is to say what you, I think, entirely correctly frame as traditional rights of settled property and contract expectations on management side, comes into conflict with this new fundamental right to collective action on the union side. In the end, one of them gets prioritized over the other one, and regardless of the doctrinal method by which it's done, that's how it cashes out, right? So I see this as just an appalling bind to which labor traditionally had a solution, which was to opt out, right? But that's no longer really available to them as a strategy. I have to say, any more than it's available to any of the decision makers to do so. Mm-hmm. In other words, the ECJ has this bind put in front of them, and it has to resolve it, right? So in some sense, it's trapped. The ECJ can't let it go either, because it knows perfectly well that either the domestic institutions or the European Court of Human Rights are going to engage in this kind of fundamental rights analysis. And if the ECJ wants to have a seat at the table for the negotiation and regulation and settling of these questions, it has to engage. So everybody is caught in this bind where there is no effective opt-out mechanism. And on the other hand, an opt-in is in some profound institutional sense disempowering. That's depressing. But I don't know what the solution is.
So maybe I could try to, there's something let me try to connect the papers maybe a little bit more in terms of something that Kerry wasn't able to get to. But it seems to me that Finnish workers are in a very different position from most workers in the world.
Absolutely.
So they turn to fundamental rights because fundamental rights are being used against them. Absolutely. And then they get pulled into Absolutely. It and have to use it. But that seems very different from the situation of workers in the global south and increasingly in the global north. And I should say, I asked Kerry to do the comparative work for us and to talk about Canada and the United States, so thank you for spending so much time doing that and filling us in. But a lot of the paper is actually about the changing nature of work, but also about people in the global south, workers in the global south who never had protection. They never won in the bargaining. They didn't have an alternative legal or political sphere, and certainly not one that they had succeeded in. So it seems to me that they were turning to fundamental rights for another reason. And you still have a critique about that, Kerry, but I wonder if maybe you could think about ways in which it's similar or different.
Yeah, one of the fascinating things about this conversation is that you can both see similarities, but you can see enormous differences in different theaters and different parts of the world. And Karen is exactly right. I mean, so a word about why the turn to human rights and fundamental rights for workers in the global south. Well, one is partly an effort to fill in this gap that's missing at the domestic level. that arises for a couple of reasons. It could be because there are no formal labor laws on the books, and that's sometimes the problem. But the larger problems really lie in the fact that they may only reach a very small number of workers, maybe only workers in the public sector or only workers in the formal sector, when a very large number of workers are effectively in the informal sector. Like, the reach of the rule of law is scant if it's present at all. But the other thing, and I think this may have come up already in this workshop, but that's the effort to use global supply chains as the regulatory unit and also the regulatory body, right? So a large part of the story in the Global South is in fact not simply the effort to formalize labor law and extend the protections to all those workers who are now outside them, but rather to have industries and transnational firms develop labor standards and to them and of course themselves to take responsibility for realizing them. And those almost invariably deploy human rights, and more particularly, they sit, almost all of them, on the 4 core labor standards that are identified in the ILO Declaration on Fundamental Rights at Work. So you see everywhere corporate codes of conduct that invoke basic workers' rights, freedom from forced labor, freedom from child labor, freedom of association, and freedom from discrimination, right? And so there's an enormous debate about the extent to which that's a good thing or a bad thing, but it is absolutely right that it's designed to fill in a complete regulatory vacuum in respect of labor standards in large parts of the world. I could go on.
Did you want to say something about that?
No, it just sounds right to me. Principle. Why don't we open it?
Yeah. Okay, so get my attention if you have a question as we go on. But first, let's take a couple from this side of the room. Yes, Augustine.
In relation to the dynamics between collective bargaining and individual rights, I was wondering if it is not useful not to think about, or also think about, not only about global south or global north, because there have been some recognition of individual rights since the 50s in some countries in the global south, but in groups of workers. So we have the housekeepers, the sexual workers, the people that work in prison. So what about that and the tension between collective bargaining and individual rights?
So I guess the place where this conflict or the discussion about the utility of individual rights versus collective rights is most developed is in respect of sex work, right, and trafficking. So there's a big debate about whether the problem of trafficking should be addressed or could be addressed through a criminal law frame or even a human rights frame on the one hand, or versus a labor law frame on the other. And it's a great question because the question is, what if you look at this as a problem of labor instead of a problem of exploitation or criminal law? What sorts of entitlements do you get? Would it actually help the workers who are involved more than individual human rights or criminal law protections or criminal law sanctions against the traffickers, right? I think that there are reasons to suppose that collective rights could be extremely useful to other workers, not just the traditional industrial worker. But I think there's also no question that the nature of those rights would look very different. So maybe the split isn't necessarily, again, always individual versus collective rights, but old versus new forms of collective rights as well.
I also like the question insofar as to me, it's another version also of Karen's question, which is to say, there are workers and there are workers and there are different places and different times, and isn't it in fact the case that we could imagine that the relationship between individual rights and group rights, or individual rights and fundamental rights, could vary from place to place and time to time? And I think the answer to that has got to clearly be yes. That what fundamental norms mean to the Finnish workers and what they mean to the Estonian workers now is obviously two very different things, and what looks disabling to one could look empowering to the other, I think is true. Now, I would say that the case presents itself, this particular case, I'm returning to the case only because I am disabled as a labor law person. I'm not actually in a position to give broad answers like Kerry can on labor law questions. It seems to me that yes, indeed, fundamental rights could be filling a vacuum, as you suggest, Karen, for the Estonian worker, relative to the high-priced, protected Nordic worker. I think that's clearly the case on the one hand, and on the other hand, I would feel a lot better about it if I thought that actually the Estonian worker was winning something durable and that would be protected in some meaningful sense down the line. I actually have no confidence in that at all. I think that actually what the Estonian worker is winning is arguably what a worker in a right-to-work state is winning, and I'm not convinced that that's winning a whole hell of a lot either. To me, these are largely, I have an American realist response to this, which is this is the winning of certain kinds of abstract rights, the actual content of which I would want to know a lot about before I could pass judgment on whether it was a win or a loss, but my priors would lead me to believe that this is going to turn out being more of a loss than a win. That's my basic take.
Yeah, and I think, you both share the critique of the turn to human rights or fundamental rights, but you just are able to invoke an alternative that is more, that sort of, in a more than nostalgic way, but that really was working for those workers in a way that Kerry's story isn't able to do.
Absolutely, and right.
But I also just, I think with this question, it seems to me that it does call up I heard it more as a breaking down the geographical boundaries.
Yeah.
Mm-hmm.
And thinking about the different kinds of work that people do within
Yes.
particular countries. And I think that you actually have a story about that, in part about how the move to informal work is happening in the global north as well, right?
Yeah, absolutely. And I too heard the question as a very useful querying of the distinction between north and south and industrialized and emerging. And that's absolutely right. First of all, there are industrialized sectors in the big emerging economies right now that are highly sophisticated. But also, one of the things that we're seeing is a kind of deformalization of work in the north, even in the most advanced industrialized countries. Any city, any big city in the US or Canada, you can find all kinds of people who are engaged in what is de facto informal work. And there's absolutely no question that one consequence of the financial crisis in Europe and in the countries in the periphery as well has been an explosion of people engaged in informal markets, because formal levels of unemployment are simply unsustainable. Youth unemployment is over 60% in Greece. People, you can't survive. People are going to do something else, and the something else that they're going to do is some form of gray market work or informal work or barter work or something to survive. So it is absolutely right, I think, to think about informality or various forms of, a spectrum of legal protections and a spectrum of places in which people can be located in relation to law that is getting very sort of geographically muddled right now. I think that's exactly right.
Yeah, Lynn?
So this is for Dr. Rittich. So when I imagine your suggestion for a new regime to protect workers and their rights, I'm just wondering, who do you imagine spearhead it, where would we start, and do you see an end?
Yeah, thanks for that question. I don't think there's one single way to do this, which is why I think some, diversity and experimentation and pluralism is probably a good thing. But let me answer your question by talking a little bit about what we've discovered so far about what does and what doesn't work in these kinds of non-state and new governance modes of establishing workers' rights. For example, using corporate codes of conduct and supply chain management and so forth. Because this is a burgeoning industry, it's where all the action is going on in many, many places. And the initial experiments with it were pretty disappointing. The idea that you could have fabulous looking codes of conduct or things that were at least significantly better than what was there before, but the extent to which they actually changed things on the ground was pretty hard to establish, right? Not much evidence that things were a whole lot better. And of course, so you have, the worst example is of course the Rana factory collapse that happened just about a year ago in Bangladesh, in which over 1,100 garment workers were killed when the factories that they were working in was collapsed. The interesting thing here was that there was an industry standard, there was a code in place, right? It clearly was working. So what do we know about what makes for better and worse possibilities here? And I think one of the clear indications is that they actually don't work without significant input from workers on the ground and organized input, in the sense that it's actually quite difficult to know what the most significant problem is and how best to tackle it without input from the people who are literally experiencing the conditions of work. So even these new forms of workplace governance, it seems pretty clear that you need some form of workers' association and collective action to be part of the story, if only as a conduit for crucially important information, right? So that's only a partial answer, but I think some form of worker organization is crucial to reinventing this and to responding to most of these problems, which is why, even though it might look very different, a key issue is genuine freedom of association. Can you actually form an association? Can you act collectively? Do you have basic protection to do that? Or are you likely to be shot for even trying to form an organization? Rebecca.
So on the same line of pressing for something a little more tangible, you mentioned briefly in your talk and extensively in your paper the idea of taking a closer look at the background of economics that labor law operates in. So monetary policy, fiscal policy, and these big macroeconomic ideas that we usually don't take into account with labor law. And I was curious what would be a more practical, something that someone who wants to advocate for labor law, how would you apply this awareness, saying that, well, I know that a money market curve, when it moves this way, is going to favor, price stability and decreasing inflation. If we move it the other way, it's a bigger focus on unemployment, and having that mindset. How do you take those big ideas that really have been stuck in academia and try and apply them as an advocate for labor rights?
Are you perhaps Tova?
You're
Oh,
No, I'm
not.
actually
You're
Rebecca.
Tova.
I also read labor.
Okay, great. Okay, great. So thanks to both of you for your questions and your queries. So one way to say is, why talk about all this stuff anyway, which is on the one hand both highly relevant, but also highly technical, right? And material that's really, really unfamiliar for lawyers and for labor laws. Like, why did I walk through this? Why did I rehearse it? Why did I make people read this? And what can we do with it? The utility of doing this, I'm not going to make a general argument that you would always want to start there. The reason I thought that it was important was that it seemed very, very clear in the context of crisis management in Europe that decisions about fiscal austerity
and in the European Union, a very imperfect monetary union, was actually the proximate driver behind the attack on labor law, right? And that it wasn't gonna go well for workers as long as we were committed to these sorts of things. So as activists, as labor lawyers, we may not feel very comfortable starting there, but it was just a reminder that in some cases, maybe that might be a useful place to start. But even before we get there, back to the issue of, before we try and solve the problem, maybe what we need to do is have a better understanding of the problem that we're trying to solve and what's producing it. And so the idea here was simply that one of the reasons we never, as labor lawyers, think about macroeconomic issues is simply because they've become questions of technocratic governance, right? That we leave that kind of stuff to the experts. So a little bit of the impulse behind that description was simply to remind ourselves that actually there are decisions here that dispose huge stakes for different groups. That if you decide that you're going to have really tight monetary policy, you're likely going to, keep the levels of growth down and the levels of jobs down and the levels of unemployment high. That may not always be your number one issue if you're interested in workers' rights, but there are times when it might be really, really important, and the crisis turned out to be one of those times when, for example, the decision in the US to engage in non-standard monetary policy, quantitative easing, I mean, that saved, some estimates are, it saved at least 3 million jobs. So that was actually really important. So that's a kind of roundabout answer. I guess the major purpose of really the idea of the paper was simply to open up the idea that the place that you might want to start, or that you might most productively start, could be located in some surprising places and in some remote places. So let me give one example coming from Doha. Karen Engel and I were both teaching in Qatar at the beginning of January, and one of the huge questions there was what to do about the really bad labor conditions of all the migrant laborers in Doha. And there is a spotlight on it, and there's in fact a big Amnesty International report on this that was released in November on this. Why? Because there's a huge construction building boom going on in Doha. So one of the ideas is, well, if you want to think about how best to try and change things on the ground, where would you start there? This is an absolute monarchy. You could start with the Qatari royal family if you wanted to, but you could also think about the potential of using FIFA, the regulator of the International Football Association, as a place to start and to organize. And here's, if you were an activist and wanted to think about, well, how actually would we mobilize to assist the workers in this situation? How would we do it? One possibility is that you would do it in this very unusual way by trying to get the Football Association to pay some attention to this and to use its bargaining power and leverage to assist workers. That's not normally where you start, but it might be a very productive place to start.
Okay, I saw a hand over here, and there's one over there. So if you want to get on my list, you could raise your hand now. And okay, I have you next. Okay, so yes.
This question is more for Professor Lasser. I'm curious, you sort of posed the Viking case and the move to fundamental rights in Europe as sort of the fundamental rights of the firm versus the fundamental rights of labor.
Yep.
I'm guessing what role the states themselves play, or sort of how their rights come into it in the European system. I'm not intimately familiar with the European system. Somewhat familiar with the sort of freedom of religion and the precedent of the Human Rights Court, European Human Rights Court. And there, my understanding is that the states have a great deal of deference is paid to the states in how they craft sort of their policies towards religious freedom, and may then allow them to go much further than you'd expect in sort of at least cutting into the fundamental freedoms of their citizens. I'm sort of curious what role, if any, the states' rights play in this context, in labor context, or sort of the move to fundamental rights in general. If the court's really talked about it at all, or if you anticipate, that coming into play more as sort of a third party with sort of, substantial rights and history of its own, and given sort of different labor histories and movements in those countries.
Yeah, it's a great question, and a complicated one. So, so there are different levels to this. One is, what is it that the states are doing in their own systems? That would be one level of the question. And the second part would be, what is it that they do when those systems are being challenged more or less directly, when cases are brought to the European courts? Now, what Finland was doing internally had its established system, and that's how it regulated labor relations. It was relatively actively involved in the sense that when you would have these labor institutions, there were really three sets of actors sitting at the table for the negotiation of and settling of disputes. One were labor representatives, some were management representatives, and the third entity were state representatives, right? So it was actively involved and committed to this regime, and had been for decades and decades and decades. All right, that's one answer. The second answer is to me the really tough thing, is what happens when these regimes, and they can be about labor law, but they can be about absolutely anything, whether it's regulation of religious freedom or free speech, or it could be, there have been all kinds of challenges to, and this is how I first came to the question, to decision-making procedures by courts, right? How do they actually, what's the decision-making procedure, and does it constitute a fair trial or not? Right? That's how I first came to the question. What happens when these get challenged at the supranational level in front of these courts? And the answer is that they tend to defend whatever is the regime in place, although not always, and they are given more or less deference depending on what the supranational entity kind of feels like doing. And it's not consistent across the board. So it can be that for things like religious questions, or touchy social questions, abortion questions, and things along those lines, it can be the case that the states are given a good amount of deference. But even there, it can vary from one subject matter to the next. But for other things, there's just stunningly little difference given. Now, I'm not sure where I stand on that, about whether I'm actually overall in favor or against the granting of deference to states for what they're doing internally. My immediate impulse is to say, actually, that really depends. Tell me what subject matter you're talking about and which state. But I think that in practice, there's no clear answer to this. Finland protected itself, and other member states immediately came to the defense of the Finnish position, and the ECJ just wiped it out. It certainly is the case that in the domain that I first came to these questions from, and that was, how was it that the French high courts were engaged in their judicial decision-making procedure? It was shocking to me that, I'm not saying that I was in favor or against, but it was amazing to me that the high courts in Europe were willing to condemn the decision-making procedure that the French courts, and because the French had been so influential for hundreds of years, that also meant the Italian high courts, the Dutch high courts, the Portuguese high courts, they all went, the Belgian high, they all went down in front of the European Court of Human Rights idea of what a fair trial was. Amazing. Imagine a court in Mexico City telling the United States Supreme Court, what you've been doing with clerks, actually that's been violating everyone's right to a fair trial since the beginning of time. It would go crazy in front of that. So there's no easy answer. The courts themselves, the European courts, are all over the place on the domains and on the particular questions. And the national legal systems have protected themselves as best they can. They almost always have a defense mechanism, and sometimes it's effective and sometimes it's not. Let me add one final thing, and that is, it's a little dangerous to treat the domestic legal orders as if they were a unitary thing. It's very often the case that there are disparate interests within the domestic system, and they're pushing for different things. So in Viking, that's easy. You have, labor and management have very different takes on what the Finnish system is and should be. It's also the case even in the fair trial stuff. You can have high courts within the French system that are dying to maintain whatever is their procedure, and then you'll have reformers in a different institution who are actually dying to use this as a mechanism to produce reforms that they would not otherwise be able to produce. So they'll use Europe as an excuse and as leverage. So it's complicated.
Okay.
Yes.
Viking reminds me of Citizens United in that you're doing these artificial corporations with these fundamental human rights, as if a corporation can have human rights. And to me, it comes down to a very basic question of you have labor versus the investor. The labor is in the trenches, whereas the capital can kind of go do what it pleases. It seems like that is, in the final analysis, that has to be worked out. In the United States, we guarantee a process. It seems like other countries are moving towards guaranteeing human dignity. Do you see that might, in the final, result in basically arriving at that analysis that has to be made? That basically, the labor, human rights are more on the line than, say, the investors.
So is the question, do we think that courts will come to that conclusion?
Yeah, basically. I mean, I see you mentioned basically everything's falling into fundamental rights and so forth, and I see that probably has to do a little bit with European constitutions and so forth being guaranteeing more than just the process that we do, but trying to arrive at some more basic human rights. And so that's sort of sucking everything into being sort of fundamental questions. And I'm wondering if at the end of the day somebody doesn't simply basically say, look, we have to prioritize and create a hierarchy. Is it the corporation, which is investors and stockholders, or the people that really matter, the people who are actually, this is their occupation, their profession? Where do their rights fit into that pecking order?
Okay, a couple of answers here. And I think one very real possibility is that we never actually get any kind of final resolution to that question. And the reason that we don't is the proliferation of different tribunals and different sites in which these questions are being litigated. So just to stay in Europe here, it's entirely likely that the European Court of Human Rights might come to a different determination about the relative balance between the interests of labor and capital, right? In a case, and I think both of us could imagine that happening. But then you still have the decisions of the European Court of Justice still sitting out there, right? So you have a kind of flat landscape in which you have competing and sometimes conflicting decisions of different tribunals, right? So that's one possible future, I think. And I would say that given the number of non-state actors or hybrid public and private actors who are now engaged in developing labor standards and talking the language of workers' rights, here we're thinking of everything from the UN Global Compact to the industry codes. Just imagine more and more different ideas about what it means to respect workers' rights and how you can resolve them. So I think that's one very distinct possibility. The other thing that I think we might note is, remember again and I'll just hand it over to Mitch, the reluctance that courts have to weigh in on this particular question. And one possible inference from all of this is, don't expect to win through courts what you can't get in the political arena, right? So if you want a better balance as between the interests of labor and capital in any particular situation, you should understand that as fundamentally a political task. And the courts won't do all the hard work for you, and they're not that likely to row hard against political trends when they're moving in the other direction.
So I agree with all of that. like to give a slightly different cast to the question that you asked, and that was the dignitarian question that you were asking. There has been endless ink now spilled on whether the turn to dignitarian approaches, right? This is all in the end about dignity, and whether that would be an effective mechanism for trying to rebalance different kinds of rights and interests. My basic inclination is to say I don't have any greater faith that a dignitarian turn is going to do something that the turn to fundamental rights already failed to do. And again, that's a depressing answer. I understand the impulse, and the impulse is, well, you know, goodness, isn't this about dignity and dignity of a corporation? What the heck does that mean? Dignity about a person, that means something, so I'm with you, right? Do I think that actually, as a legal category, do I think that that's going to effectively compel a set of substantive answers in litigation that I would agree with more? No, I feel not confident that that's going to happen, because I think that once again the devil's going to be in the details. Dignity can be read 6,000 different ways, and are you really in the end going to cast it in terms of an individual person as opposed to a corporation, or are you going to cast it in terms of a right to a dignitarian right to work and a right to free speech and to free movement, and what you're foregrounding is an idea of work and movement, or are you foregrounding an idea of individual versus legal fiction? You can do that work through fundamental rights. You can do that work through dignitarian stuff. I don't particularly see why it's going to be done in the name of dignity if it's not already done in the name of fundamental rights. So I'd like it to be so. I'm not convinced, but I also know a whole bunch of people who really disagree, who think that actually there is an inherent resonance to the idea of dignity that will in fact push things more down the line that one might hope for.
Adelaide.
I was curious for both of your perspectives on some of the byproducts of the financial decline in Europe as well as the US, and just some of the supply chain and regulatory, like corporate compliance laws, and how they affect labor rights. I'm thinking most specifically about like the Foreign and Corrupt Practices Act and Dodd-Frank in the US, and though they offer some aspirations for keeping things more financially transparent and therefore creating, especially in developing markets, more formal positions, I feel like what they're actually doing is retracting Western interests from being a potential channel for some more progressive workers' rights. I'm curious to hear y'all's perspective, and also more regulations that you might be tracking and are curious about their result on the final labor market. Sorry, is that clear?
It's above my pay grade.
So I think, yeah, I think actually I don't feel like I can really give you an adequate answer to Dodd-Frank and the legislation that's specific to the U.S. because I actually haven't been studying it, and you would really want to, for sure. So that's not a very happy answer to your question, because I'm sure it's worth studying.
I'm curious, I think mostly just in forms of, there's a lot of emphasis these days on corporate compliance.
Yep,
and that's a lot of times formed from an interest on domestic markets, but it has this overarching grand effect on developing markets.
Yeah. So, I mean, the analogy here would be, of course, to corporate compliance in respect of labor rights. And I mean, I guess one question is how they're structured and how they're institutionalized, and who has a voice and who doesn't, and who, you know, that is always the basic question. And so the observation about corporate compliance efforts so far is, or one key issue, one thing to watch would be the extent to which they are both in design and in operation completely under the control of the corporations themselves, right? So what's the role of external monitors? What is the specific expertise of the monitors? Do you have Price Waterhouse coming in, trying to determine if the labor standards are being complied with? If so, why would we think Price Waterhouse would know a labor standard violation? They just don't. And so you get into lots of really interesting questions about the design of the regimes, who's playing a role. A lot just happens at that level. And there's, I think, more and more knowledge that I've tried to suggest about better and worse ways to go about that. But clearly you don't want to leave it totally in the hands of the corporations. I mean, a lot of these things work. I mean, you're exerting reputational pressure on those firms, and that can often be very powerful. It can be effective, but it's also true that firms will often buy reputational gains at the cheapest price that they can, right? So it's not necessarily the best way, although it might be part of the arsenal, right? Part of what you want to do. But yeah, regime details. Neville.
Okay, I'm depressed. And I'm convinced by the claim that what you're calling the turn to sort of fundamentalist fundamental rights, it's bad for labor, and that it is actually helping in the production of precarity across the world. But at the same time, it looks like that's not going to go away. So my sort of politically optimist question, and I like the turn to the political that you were suggesting, that we can't ask the law to do everything, would be how could one mobilize these fundamentalist freedoms, or what you're calling fundamentalism, or fundamental rights, in the other direction? And so I'm having an impossible fantasy here. So could what happened to Pinochet happen to the Koch brothers? Like how could these fundamental rights be used against capital in the interest of labor? So what happens if one goes on the offense rather than sort of continue playing catch up in relation to sort of labor law issues?
So it's a great question, and I'm not sure exactly what it would mean to go on the offensive, right? To me that's the hard question, is what is exactly that one would do. I mean, it seems to me that it's engaging in a form of combat, if you want to put it that way. It's engaging in a form of combat that unfortunately does not seem to end well, right? And I think that the answer, which is Kerry's answer, which is in the end, it's the most traditional labor answer there is, right? Which is organize and do something at the political level is the answer. It may well be that that's the only effective way around it. That's not saying anything remotely new, and it could be that that's the case on a sector by sector basis. It's to some extent what I took Prabha, what's her last name, writing about sex workers in India, Kodiswaran, to be writing about, was basically thinking about this in terms of labor law and how is it that you would effectively manage to band people together in order to try to produce results. Now, that's not to say that the fundamental rights turn or the dignitarian turn could not have a compelling ideological benefit, right? That it could have an aspirational benefit that could be leveraged for the purpose of producing certain kinds of political mobilization. But that's where I would leave it. I would say it's great as an aspirational turn. I would be leery of trying to engage in that as a primary mechanism of actually trying to produce legal change. Now that said, the trap is there's also no escaping it, right? So I don't see how you can just drop it and walk away. You're going to have to litigate this every day. The only further answer to that, I suppose, would be you could litigate it well or you could litigate it badly. And litigating it well to some extent would be to say what's good for the goose is good for the gander. And if in fact the market actor has the capacity to make certain kinds of claims, like the firm's claim that the union can't interfere with its right unless it can justify its interference, surely it must be the case that the union should be able to say the same thing. Well, now we have a recognized right. Surely management can't in fact interfere with our right without having to justify it, which is precisely what the Viking court does not do, right? Okay, do I think that's going to yield great gains? I don't think that's going to yield great gains. I think in the end it's going to be mobilization, and that's as good as I can see.
Maybe there's just one other thing I would add that I think is relevant to it. I don't think it's in the end hopeless at all. Simply because what happens at work is too important to too many people. It's just hugely significant, and people will always try and make things better to the extent that they can. But a dimension of it that we haven't talked about that's important is how we understand the connection between markets and market freedoms and social benefits generally. And we've just been through an era in which the general expectation was that mobilizing market forces and integrating markets and removing impediments to transactions and investments was in general a good thing. It's in general better than the other thing, that it will produce a bigger pie, it will produce welfare gains for everybody. And an enormous amount of institutional legal change has proceeded on that basis for the last generation. Now, one of the things we're starting to see is that there is a bit of a dark side to that narrative, right? And that, in fact, the distribution of those gains can be highly unequal, and that can produce problems not only for the people on the losing side of the deal, but for society in general. And so I think our understanding about what the broader processes of market exchange are and the ways in which they assist us, but the ways in which they could also be usefully cabined and changed, is going to be part of this broader political transformation as well. And maybe that's a change in the narrative will affect the way we think about fundamental rights. Maybe it will push us towards broader, thicker, more capacious ideas than narrow ones. There's no particular reason that it couldn't go in that direction. I mean, the book of the month right now is Thomas Piketty's book, Capital in the 21st Century. And this is a book about, it's a cautionary tale about the possibilities of the consolidation of wealth in the hands of very, very small number of people. And it's, everybody is talking about it. So there are always, the wonderful thing about doing this work is it's extremely interesting to think about, but there are always surprises around the corner, things that you can't foresee that will change the nature of the conversation and that will change the discourse. And so I'm just sure we'll have moments.
Yeah, I have a question. You mentioned the rise of fundamentalist, fundamental rights in Europe, also affecting domestic systems. Could you explain that a little more?
Well, I mean, this has been to me one of the most amazing things to view, and my prism is heavily oriented towards the French. And that is to see the speed of the transformation that has actually occurred. So I would never have imagined, when I was doing my initial research on the French legal system 20 years ago, that things would look the way they do. The speed with which those domestic legal orders have incorporated fundamental rights, discourse and analysis, and the full extent to which that has changed the way in which even moderately, not just elite, but moderately sophisticated lawyers in those systems argue is an incredible thing. I could never have imagined a change occurring that fast. We were talking about it over lunch today with a few of the students in the class. It's an astonishing thing that you have private claims, just routine contract claims, where non-compete agreements in employment contracts, where the employer says to the employee, so here's a seeming victory. Employer says to employee, prospective employee, okay, we hire you, but you have to sign this agreement not to leave the firm and go to a competitor and work within 2 years or a year of your leaving the firm. And French courts standing up and saying, actually, this violates a constitutional right to work, right? So this is an seeming employee gain, right? So it's not as if fundamental rights norms cannot be used in a dignitarian or offensive manner, or let's say, to make for benefits. So all I'm saying is, coming from the outside, looking at it as an American, the speed of the change has been just stunning to me. I would never have thought it possible. Sometimes it works out well, and sometimes it doesn't. I'm a little pessimistic about overall where it leads, but that doesn't mean that there aren't localized victories. What prompts your question?
What I was thinking about, because the Viking case involves basically on the Viking side, invoking freedom of movement, right?
Yeah.
And I thought about how would that affect pure domestic cases, because it doesn't, right?
That's absolutely true. But you get it, the way you get it in the member states is you're getting it through constitutional doctrine, just like you would in the German case. You would get Lute-type judgments where you actually get the incorporation of fundamental rights norms in straight horizontal situations where the state is seemingly uninvolved, right? So I see this as it certainly is a rather simultaneous set of developments on the constitutional front domestically and on the supranational front through the European institutions, and I see them as very, very much related. Variants on the same kind of thing that produces an overall effect that's self-reinforcing, seems to me.
So we have time for one last question. Yes.
I wonder at the role of socialism in, interestingly enough, sort of advancing, the workers' rights kind of situation. You mentioned Greece, and what comes to mind is during the Great Depression here, we had the WPA and the Least Works programs, which I understand were actually sort of an extension of a long-standing tradition that existed in this country that's sort of been whitewashed from history, and that is, we had a civilian draft. If you look back in old Texas statutes, you find there's a county overseer, and if you were a man between 18 and 40, you could be expected to go work on roads and bridges and other public works. And of course, we've done away with all of that. But to me, the idea of sort of the right to work and a job and all that sort of stuff brings into focus then workers' rights and unions and all that sort of stuff. And I'm kind of curious as to what's going on in, say, Greece and so forth. How are they addressing that when you have 60%, as you said, sort of unemployment of youth? Where do you go from there if you're not putting them to work?
Well, the European Union, of course, itself provides a safety valve, right? The freedom of movement of workers means that there are more Spanish and Greek workers in London now.
Soon to be in Estonia.
Pardon me?
Soon to be in Estonia.
Soon to be in Estonia. And of course, the Irish are migrating out of Ireland in numbers not seen since the Great Famine of the 19th century.
I think we do that in the United States. We made it legal for hobos to ride the rails.
Right.
To get around. And so, in a way, that's one supply and demand.
But just to speak directly to socialism, another part of the story, of course, of the sort of decline in collective labor rights and social rights generally is, of course, the fall of the wall and the apparent success and hegemony of a particular model of market society, right? So part of the strength of social rights and labor rights in the post-war era was precisely because of the existence of another model on the doorstep, right? And that model is gone. So when we're thinking about the balance of political forces, this is something that changed the landscape profoundly. So we won't go back to that particular moment. I think the question is what convergence or configuration of political forces might produce more attention to just questions of inequality and basic conditions of work. I mean, the situation in the United States is extremely interesting right now. For the first time ever, household wealth is declining in the United States, and wages and incomes in the United States have been flat for basically a generation. And people know this, people are experiencing this, that even though the economy is growing, for the vast majority of American households, they don't have access to more income, even as things like healthcare and housing and of course higher education are becoming really, really expensive. So those are the sorts of things which I would expect to change the landscape.
You would have a final?
No, I can't do better.
All right. Well, thank you both very much for a terrific And someone say something optimistic so we can leave. I'm sure that Kerry and Mitchel optimistically will be happy to talk to folks privately up here.